Hello, everybody. I've got the crying fez on today. Hello, Ava. Hi, pretty girl. You gotta start the stream out right. With Ava, of course. Hello, Nana Laura. Hello, Eileen E. Carlin. Hello, Sir Philip. Good to see you. Hello, Kova42. I'm so happy you're here. I won't tell the boss. Hello, C-Rex. Hello, Tiana Miller. Treat number 2. Hello, Jenny. Hello, Spider-Man. It is a kitty. You know what he says? You know what he says? He says, "Happy birthday, Eileen E. Carlin." Ava says so too. Well, I mean, that's what it sounds like to the untrained ear. But, you know, Earl and I, we've been talking for a very long time. So I've gotten to know what all of his meows actually mean. I hope you've had a wonderful birthday. Thank you so much for being here. So we've got a pretty full, wild show tonight. I don't know if y'all remember the 80s movie Howard the Duck. Yeah, I remember Howard the Duck. I was really little when it came out, but I remember watching that movie. And Howard the Duck makes a surprise appearance tonight. I think you all are gonna love it. It is still widely known as the best movie of the 80s. You had 3. Oh, I highly recommend it. I don't know. Maybe that's where I get some of my humor from. You know, I grew up with Howard the Duck and with Who Framed Roger Rabbit, and oh my gosh, oh my goodness. Oh, well, I know there's gonna be, there we go, somebody has seen it. I grew up on it. Anyways, hopefully y'all will get a laugh anyways, even for those who have not seen it.
We are here in the case of Myrick Harris.
Wrong one. Wrong one. I'm a professional.
We are here in the case of Myrick Harris versus Erica Milligan, case number 24-12769 PP. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Miss Milligan's timely objection to a personal protective order that was signed by Judge McNabb, looks like back on the last day of 2024, 12/31/2024. So as a preliminary matter, I'm going to ask that the petitioner and respondent state and spell your names for the record. We can begin with petitioner Mr. Harris.
First name is Myrick, last name Harris, MYRICHARRIS.
Thank you, sir. And Ms. Milligan.
Erica, ERICA, last name Milligan, MILLIGAN.
Very well. Ms. Milligan, I apologize. We had you incorrectly on the screen there. And Ms. Milligan, you filed the objection essentially saying that the basis stated by Mr. Harris in his request for the protective order were untrue or incorrect. I will note here that the PPO is signed by Judge McNabb states that it is granted, of course, as most PPOs are, without a hearing and following a domestic relationship. So the burden now is on Mr. Harris to prove that at least some of the incidents that he is citing here in his complaint would qualify as threats or harassment under the PPO statute. So as a first matter, I'm going to swear you in, Mr. Harris, and take your testimony. If you'd please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. And it indicates here at the start of yours that you were served with a TRO because Miss Milligan alleged threats to kill her. Does that actually mean a PPO that Miss Milligan took out against you?
Yes, sir.
Okay. All right. And then it looks like she obtained an extension here. This is similarly going on along with what I'm understanding is a family case, maybe down in Louisiana. But essentially, the first allegation here is after being used that parenting app or for communication, you state that Eric constantly taunted me, called me names in the act to get a negative response. Do you have any printouts or specific information about what was in that parenting app?
Your Honor, I have evidence that I cannot submit to the court today. I was told by your court that I have to serve her with everything that I bring to court today. But I do have those. I can get those police reports, pictures, videos, social media, whatever you need. Those things have already been turned in to the Louisiana court during discovery.
Okay, and what is the parenting app ordered by the Louisiana court?
Yes.
Is it My Family Wizard or is it a different one?
We use App Close.
App Close, okay. And can you give me an example of some of the language or threats that she made to you on that app, if you can recall them?
She's never made threats in the app. What she would do is just when I would ask about my children, and I would have to ask things repeatedly because she wouldn't answer. She would say, "Are you stupid? I've told you one time. Use your brain. Don't be dumb." Things like that. The harassment more so came on social media.
Okay.
Days and days for about a year. I have all that evidence that has been turned into the Louisiana court during discovery. I can present it to this court, videos and comments and different things from social media and antagonizing.
Okay, and these are the ones you cite in your petition here. You say these are under page names at IG?
Yes, sir.
Okay, and what are some of the examples of the harassing statements made on social media?
Allegedly we were married and saying things. If he did this to you, if he did this to me, he'll do it to you. It just, it's, Your Honor, there's so many. I'd have to print them out to give them to you, but it's a lot of videos that are present just talking about me. And what happened was with those videos, it shined a bad light on me in the Grand Rapids community because a lot of people that follow me are friends with her on social media. I've had to stay in my house. I don't go anywhere. People are, basically people have heard her stories and they allege that I was a married man cheating on my wife with someone in my church. And it's just gotten bigger and bigger and bigger and bigger. So the judge in Louisiana has every one of those posts on every platform and those videos. It happened with several for like a year. It's every week or every few days, there was another video being made, another video being made. Some videos got up to over 500,000 views.
And do they name you by name in there, Mr. Harris?
They do not name me by name. No, sir.
Okay, so they're, in other words, they're saying, I'm married to this guy or was married to this guy, and here's what he did to me. But I think your statement today would be, well, the people that know us in that context would know that's directed at you.
Yes, sir. There's one video that has a picture of me. Her father's ex-girlfriend made a post that I gave Miss Milligan, I'm assuming bacterial vaginosis, and a picture of me and a picture of a pH scale. And Miss Milligan shared that post on her page. And all these things kind of gained traction from the day one. It was her telling her story about what happened to her. And over time, they gained more and more traction. Her numbers went up, her followers went up, but that one post is a picture of me with a glass of alcohol in my hand that was taken during a conversation that we had. And it was alleged that I gave her father's ex-girlfriend alleged that I gave her bacterial vaginosis or something, and I smelled like fish. It was just a whole lot of negative connotations that have spread throughout the Louisiana community and the West Michigan community.
Okay. All right. And then finally here, there is an allegation that she hacked your corporate email and made herself the admin on that account and then routed, it looks like perhaps your corporate emails to her email account.
Yeah, so that was a few things that happened. This was back last year. I was talking to my attorney and never getting any responses through or back from him. And then I found out that my email was logged into in Baton Rouge, Louisiana, and it showed that Ms. Milligan had made herself the admin over my company email. And this is from Google. And it had timestamp, date stamp, IP addresses as well. This PPO that I asked for came about because for Christmas, Ms. Milligan asked me to come to Louisiana to visit my daughter. And when I got down there, Ms. Milligan drove up here to Michigan, busted the window out of my house, came in the house, took things from the house. The judge gave her 4 things on paper in the PPO out of the house. When I got home, Ms. Milligan had been in the house, I'm assuming for a couple hours, whatever, taking things. And Kent County, I called 911 when I got home, got the Kent County Sheriff's Office out. And nowadays an investigation because it appeared to be that my cameras had been hacked into, and it showed a date and time that my cameras had been accessed by another device that had an IP address. And I was on the plane flying then. I can show that when all this happened, I was in there flying back to Michigan.
Okay. All right. Well, I think you've testified about, a sufficient number of incidents to justify a PPO being in place. Let me get a response from Miss Milligan. But Miss Milligan, let me swear you in first. Would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. Ms. Milligan, you've heard Mr. Harris's testimony, and you did file an objection. You referenced the action down in Louisiana. Obviously, there is a matter going on down there between the two of you. You know, it looks like a divorce or a domestic case. What about this other stuff that he's alleging about online harassment? I guess it would be helpful if you started out with that.
Yeah. So I'm not quite sure. A lot of the things that Myrick put in there is half truths, or it's either a lie. I'm sorry. So I was made aware of this in sometime in March, I believe. So we're going through the discovery process for our child support case, and his attorney sends this over. So it's to my understanding that this was supposed to be served back in December. So I never was made aware of this until the discovery process. And once I found out about it, I contacted the court to get more information because he never properly served me.
Well, he did properly serve you. It just wasn't, you know, he was granted the order way back in December 31, but then, you know, you weren't served with it. Thus it didn't take effect under Michigan law, because obviously you got to know about it being there. Until that date, it was served on you, which I will note here. Looks like it is.
He never actually sent it to me. It was sent to my attorney.
Yeah, but I thought I saw an email proof of service in here. I'm looking in the wrong place.
I
Yeah.
contacted the court, yes.
Yeah, right. And once you consent to an email as the means of being served on you, then service by email, at least under Michigan law, is acceptable. Are you saying you didn't consent to, and this is signed by Ms. Fields, our PPO clerk, at the court. Did you consent to the service by email?
From your office, yes.
Okay, well, then once you've consented, and it's noted in the record here, then service by email is acceptable. So, I mean, the net effect of that is it means it's been in effect since, you know, March 18th. It also means that your objection's timely because you just filed your objection, and those have to be filed within 14 days, and you did that. So, you know, what I'm doing now is examining the basis for the order to see if it should stay in place or not. And I think, you know, the key for you is to determine, you know, and if I'll tell you if what Mr. Harris is alleging that, you know, the most concerning stuff here is social media posts identifying him, for example, and saying, you know, he transmitted bacterial vaginosis. Well, that would be, you know, libel and slander under the law of most states, and thus it would be a, you know, a basis of a statement of harassment and for a protective order. So what's your response to that?
So, Judge, I'm breastfeeding, so I just turned off my camera, if that's okay?
Yeah, that's fine with me. I've no, I saw you swear in, so you're it's acceptable to turn off the camera. Is there any objection to her turning off the camera while she's feeding the child, Mr. Harris?
No, Your Honor.
Very well, then you may continue, Ms. Milligan.
Okay, so I've written down 17 different things to go through and respond. So I can read through these things if you like.
Yep, go ahead.
So
These are responses to the things he just testified to?
yes, correct.
Okay, go ahead.
Myrick stated, and I'm trying to ping pong from his statement to mine. So he stated that we were in a relationship, I believe in 2024, we started in a relationship. So it looks like we've been in a relationship since 2017. He stated that he added me on to the lease. I'm sorry, I got my baby right here, so I'm trying to.
Oh, that's okay. Take care of that baby by all means.
Yep. So he said he added me on to the lease. That was not true. We did the process together. And partly because Myrick doesn't pay his bills on time, so he didn't have a good credit score. So when I got with him, I got his credit right. And when we moved to the apartment from Grand Rapids to Caledonia, we both were on the lease. So it was
Okay.
my credit initially that helped us because I had an 825 and he had a much lower score.
Yeah, here's a question. I just positive. The only way I can see that being related to what he just said is regarding this alleged, allegation that you came up when he was traveling, I think, down to Louis, or I'm maybe getting it backwards here. No, you're still up here. He's down in Louisiana. Or no, you're in Louisiana. He's up here. So he said, well, I was traveling, you were traveling, I can't even keep it straight. He was traveling down to Louisiana, thought he was going to see you, and meanwhile you were up here, entering the apartment without authority. You're saying you were on the lease at the time?
Yes, I was on the lease. And in the paperwork that he submitted, he said that I was not on the lease. He may have very well signed a lease, but that lease would not have started until January 1. So I got a PPO from the judge here in Louisiana because when I was pregnant, Myrick choked me. And then he also too tried to harm me. The police were called out. I had to get a protective order because he threatened to harm me because I was telling everyone what I went through during my pregnancy, that he choked me. He kept bringing me soup when I was pregnant. I told him that I did not want the soup. Okay. I told
Was
him,
your, just to pause you, Miss Milligan, was that protective order entered down in Louisiana?
say that one more time for me.
Was that entered by the court down in Louisiana or here in
Yes.
Cook County?
Yeah. Yes, sir.
Louisiana. Okay. All right. No, that clarifies it for me. So you get a protective order against him based on what happened when the two of you were together. It sounds like past abuse from him. And I guess the key question then becomes, what about these alleged statements that are made online? I didn't clarify, and of course I haven't seen these things, the printouts of them yet, but it sounds like Mr. Harris is saying this all happened after the two of you separated, or is that not correct?
That's incorrect. This is retaliatory. This PPO that he has taken out or tried to take out is retaliatory. So he has a current PPO right now, and I have blocked him on so many different platforms. Myrick keeps creating new profiles to try and follow me, to look at the pictures that I'm posting, to look at the stories that I'm posting. I've blocked him multiple times.
Okay, well, and I guess then the question is, and I'll give you the benefit of the doubt as I'm giving Mr. Harris here as well. If he's doing that and he's seen this, has he seen posts that, could only be attributed to him? And I guess there, the one that's jumping out on me is the, accusation of this transmission of a, sexually transmitted disease one.
So BV isn't a sexually transmitted disease, and I don't recall saying that.
Okay, so you're, as we sit here today, you would deny that that was one of the things that you posted anyway.
I can't recall that. I don't believe I posted that. Someone else may have posted that.
Okay, how about other stuff on here about infidelity?
That's correct. He was cheating with a married woman at the church.
Okay.
They're in a relationship now.
Did you identify him specifically and say either by picture or by saying his name, or I mean, how did you express that on social media?
I did not, Your Honor. I never included his name. I never included any pictures with him. If they were, I covered him up so no one knew that he knew who he was. Now, what he did do is go and take pictures from my profile, and he posted on his page and say, hey, look what Eric is doing. So now all his followers are coming to my page. So now he's let everybody know this is like, when I went through great lengths to cover his identity, didn't say his name, he's like, this is me, right? Go check out what she's doing.
Okay, I'm being, slandered here, whatever. Now, were you both members of the church community when the two of you were together?
I was.
Okay, so is it a situation like he said where people, when you're talking about, hey, this guy I was with when I was in Grand Rapids, they know instantly it's Mr. Harris?
I don't know. I didn't know very many people in Grand Rapids.
You can't get into other people's heads, but I guess it sounds like, maybe it's a tight enough church community that that might be the case anyways. How about your online community? Would that be true? The people that you communicate with online?
I'm sorry, say that one more time.
Would the people that you regularly communicate with online that read your posts and things like that, would they know the history to know that it was you and Mr. Harris for a while. So if you say, hey, my ex is doing X and so, they would know it had to refer to Mr. Harris?
Only the people that I mean, I've told all of my friends. All of my friends and family know what I have gone through. I have not kept it a secret.
Yeah. And it sounds like you've posted some of it publicly, and I guess I'm more curious about what about those I would assume your friends and family are going to primarily side with you, but what about the online followers that
No one knows who he is. I've built a following and people don't know he's not
he's not a public
he's not a
figure, in other
celebrity
words.
or anything. People don't know
Yeah.
who he is, and this is for me. Let me back up. He has done more of propagating this than I have.
Okay, why don't you go and explain that to me, how that happens?
Sure. So he has done more of propagating this whole process than I have. He has built and called my followers, my mother, my father, my family members, my friends across the country. For him to say this is harming him, this is false. I think if this was harming him, he would not create posts that have been liked by hundreds and seen by thousands.
In other words, he's the one initiating the widespread, beyond a small circle of people, posts that he's identified in.
Correct.
Okay. You can continue. I know you had a whole document there that you were going to go down, and I kind of interrupted with my question. You can continue.
Okay. It's pretty lengthy. I don't know if you want me to go through.
Well, why don't you, and actually the one I'm most concerned about here, because this was the other one he testified with about here today, is what about this corporate email situation where you would have become the admin over his account? That might be a crime in Michigan at least. And what happened there from your perspective?
Yep. So if he's referring to his corporate email with Consumers Energy, I have no access to that. He and I were together for several years. So when we were together, he provided me information so that way I can pay bills. I could do things for he and I. So we've been together for some time. So maybe that's why he thinks that, but I've never accessed his corporate email. Let me also just say, okay, yeah. I've never accessed his corporate email. He's a technology person. He's in media.
Well, it sounds like you're both pretty tech savvy, or at least pretty active, on the internet with different accounts. At least what about this Wayne Whitley? Is that your account?
Yes, it is.
Okay. All right. And then also E.L. Milligan Facebook.
I'm sorry, say that one more time.
He also mentions this E.L. Milligan Facebook or FB.
E.L. Milligan. I don't think that's my profile. I think I have a new one now.
Okay.
I created new ones when I left him.
Got it. And then what about forever_Erica-IG?
I'm still currently on his phone plan right now. So he can look at all of my activity. He can track me. He can see who I'm talking to. He can see who I'm texting.
Okay.
And he refuses to release my phone number.
I see. You'd like to keep your number, and that's at least for the moment on his plan. I would expect it'll probably be worked out in the family court down there, but it just has not happened yet. So those are your accounts, and he's got in effect unfettered access to all of them because he's the owner of the phone plan.
He will not release my phone number. I've asked him to release my phone number, and he continues to track and monitor everything that I'm doing. Even my attorney has reached out to him.
Yeah, and you could, yeah, and I mean, that's really not to be decided.
That's not how that works. Just because you're on someone's phone plan, they don't have unlimited access to anything you do on your phone.
Here, in this forum, that's to be decided, that's the sort of thing that would be worked out in the family court forum.
Right, but that's also so he can keep tabs on me. If he's in fear for his life, he shouldn't be trying to track me and keep tabs on who I'm talking to and where I'm going.
Yeah, no, I see what you're saying, right. And I do want to clarify that protective orders aren't only in fear for your life. They also can be granted when a person is subjected to harassment, that is, conduct that makes them uncomfortable or distressed, as would a normal person. So it can't be, it's not subjective to every person. It's a kind of an objective every person standard that, and that's where we get up with stuff like, boy, if it's slanderous, or if a person's saying, well, he's a terrible employee and he steals money from his employer or something along those lines, then that's always considered harassment. In other words, it's not limited to threats to your life and limb. It can be threats to your employment and, mental well-being and things like that. So it's a little broader. So, all right. Well, what I think.
Can I also just say
Go
this?
ahead. Yep, you
One
may.
thing Myrick has been doing, he reaches out to me daily. We're supposed to communicate on this app close app, but he has been trying to get me off the app and to talk to him on a phone call or on an iPad where it's not monitored. I'm getting that constantly on the app. You can call me anytime. We don't have to communicate, on here. Call me on Mia's iPad. Call me off your phone. And I don't feel comfortable talking to him unless it is monitored, because I know that he twists words. I know he will change the situation and he only give you half information, such as when I went to Michigan to get my things that the judge gave me access to go and get. When I went into the house, he was not there. When I saw him come, he chased after me with my baby might have been like 10 or 11 months at the time. So he chased after me. So he gives you just a little bit, but he doesn't tell you the whole story. He twists the story. And when I left out of the house, I called the police because
Okay.
I was in fear for my life a second time having to run out of that house.
Yeah, no, and I guess I will say, it's not part of my order that you only contact each other through the court app, but I certainly think that's prudent given the situation and the tension between the two of you, that all the communication should go through that app close so that it obeys the order of the court in Louisiana. That we put those orders in place, and I've used them in other cases for exactly that reason. So then the court has access and can see exactly what the parties are communicating to each other without having to take it, any other way. All right, Mr. Harris, it looks like you wanted to say something additional. Go ahead, sir.
Your Honor, what I would like to ask for is an evidentiary hearing, Your Honor. I don't have to lie. I can show you proof. I can show you the IP numbers and everything. There is an investigation with Detective Davis with the Kent County Sheriff's Department. For everything I put in my report, they have IP addresses, they have times, they have date. Everything is timestamped. I don't have to sit here and tell you things. I can show you videos. Ms. Milligan was still using her Facebook pages up until I would say either end of January or beginning of February. I was told by my attorney to go to her page and get these. You could go look at her page right now. It's so much that's happened. She's public. You could Google right now her name and everything will come up for you. You see the last post she made, the last video she made. If you allow me, Your Honor, to clear my name in an evidentiary hearing, I can provide everything that I have told you. I can show proof to back it. You can subpoena Detective Davis. You can subpoena the police officers. When she mentioned about the police coming to our house, I can give you that police report, which does not speak highly good on her.
Okay.
I have
evidence. No, well, here's what I'm going to do today, because I also have another hearing that I need to get to that I know the parties are waiting for right now.
Judge, one more thing. Can I just say this?
Yeah,
in one of my recent messages on App Close, I can go through and provide this. He's contemplating on moving back to Louisiana, right? That's what I got, just last week or maybe week before last.
Sure.
That's not a person that is in fear for their life or even feel harassed if you're trying to move back to Louisiana?
Well, I don't know, and I really, without the context of it, I can't, it's very hard to judge those things. So what I'm going to do is I will adjourn this matter. I'll keep the PPO in place for the time being. I'm not going to terminate it today because obviously I need to review some additional evidentiary information. So do you think you can get that material to me? Do you have material you would like to submit as well, Ms. Milligan?
What do you need me to submit, Your Honor?
If you have copies of messages, posts, things like that, or the document you referred to, it sounds like you kind of rebut some of the things that he says. If you'd like to submit that to the court, you're welcome to do so. It doesn't mean I'll admit it into evidence. You still need to make a foundation that it would be admissible in evidence, and I'll do another hearing to do that. But if you'd like to submit material ahead of time, can you do that within the next 14 days?
Sure. I'll have to get an attorney. How do you guys go about attorney fees? Because I know in my last case, he had to pay for my attorney's fees when which he still has yet to pay the whole thing.
Yep. Well, and PPOs are a little bit different in that if you're charged with a violation, then you're in jeopardy of going to jail, and I can appoint a court-appointed attorney to represent you. However, to terminate the PPO, it's treated like a civil case, and in those cases, we don't typically there's not a court-appointed attorney to represent you. Now, you or Mr. Harris, for that matter, could approach a legal aid organization such as Legal Aid of Western Michigan. I don't think they participate in PPOs. I've never seen them appear for one, but you could ask, there are some organizations that provide free legal services for civil cases, because technically, a good thing or a bad thing, depending on your perspective about a PPO, is it is a civil case. It's not on your criminal record. It's not anything that you need to disclose on a job application or anything of that nature. So it's less heavy, and they go away. This one, Judge McNabb granted it for a year, so it's in place until December of this year. But after that, it would expire and it would be removed from the record. So it doesn't create a kind of a permanent mark on your record like a criminal conviction could. But all that being said, we don't provide attorneys to duke it out about whether the PPO is going to remain in place or not. You kind of have to either litigate that yourself or hire an attorney. Specifically, people do appear with attorneys, but they are usually attorneys that they are paying, to appear on their behalf. So I'll leave that in both of your courts. Mr. Harris, is that 14-day deadline to submit supplemental information doable for you?
Yes, Your Honor, does the burden lie on me to serve her with the information? I don't have the data because I was told I got to serve her.
No, it's confidential. So why don't you just send it to the court, and I will make sure. Are you going to email it to me, or are you going to send hard copies of it?
I can bring it to you. I have it's a lot of information. Or either the files are big because they have a lot of the videos from a whole year that she posted on social media. And I have the police report. I can get the police report that Detective Davis is working on now.
If you can provide a couple copies of the reports and things to me, I will figure out a way to get them down to Miss Milligan before the next hearing, so we're all on the same proverbial sheet of music.
Okay, thank you.
Very good. And Lisa, do we have a date? I think since we're going to exchange that in 14 days, it obviously has to accommodate that. More than 2 weeks out where we can continue the hearing?
The first
and we're probably going to need a couple hours if we've got a lot of documents.
Yeah, the first time I was able to find a block like that is actually June 25 at 2:00 on Zoom.
Well, then that's when we'll resume, is June 25 at 2 p.m. And
June 25th, hold on. I think I have another court date. Can you give me just 1 second?
Yep.
We're going through child custody court right now.
Understood. And I do want to clarify that's going to be on Zoom. So, even if you did have another hearing, you could possibly do it, if you're waiting for it or if it's closed. But if it's right on the same time as another hearing, that's obviously not going to work.
Yeah, I just want to make sure it's not the same date. If you give me just 1 second.
No worries.
That date is July 24th, the hearing that we have in Louisiana for custody court.
Okay, not June, so we ought to be okay.
I think we have 2 dates, Your Honor. I'm not sure. If you can let me place a phone call to my attorney's office to make sure. I just don't want to be double booked.
What
or
I'll
not be
do is
available.
let's tentatively set it for June 24th, and if either party develops a conflict regarding that date, just reach out to my office and we can reschedule it. It's no big deal.
Okay, June 24th. Tell me the time again.
June 25, Judge.
June
June
25.
25. Okay. At what time?
2 o'clock on Zoom.
Yeah.
That's 2 p.m., correct?
Yes, sir.
And then how do I contact you?
Emailing Lisa is probably the most reliable.
Okay, Lisa, can you provide me your email address and or phone number?
Yep. Is correct.
At kentcounty.gov?
At kentcountymi.gov.
Oh, let's see, hold on. Kent County mi.gov. Okay. Got it. And what's your phone number?
616.
Okay, sounds good.
Okay.
All right. Thank you both for attending today and for your civility in presenting your cases. And like you say, we'll reconvene and you do have the opportunity over the next 2 weeks to submit supplemental information to me by mail, email, dropping off whatever works best respectively for you. And I wish you both a safe weekend. Thank you.
Thank you. Oh, Judge, one more thing.
Yep, go ahead.
Are we supposed to be communicating at all?
Only through that app, it sounds like to me. You know, the protective order would prevent you from reaching out directly to Mr. Harris, with an exception for, you know, if there's a court case, you know, your attorney can mail stuff to him, of course, and you could communicate if it's regarding child custody type matters, things that the court allows through the app. Utilize the app as directed by the court. That won't get in trouble. But
Okay.
make sure that communication's limited to the stuff the court says should be on there. You can't go on the court appointed app and cuss out the other person. I've had that happen before, but that's never a good idea.
Yeah, absolutely. I don't contact him. It's just him contacting me. And when he's on the phone with FaceTime with my daughter, he's always calling me to the phone, trying to talk to me, you know, just doing a little bit too much.
Okay, well, like I say, do it as court directed through the app, and that'll be best for everyone.
Thank you.
Thank you.
I am reserving judgment and opinion. I'm not for her. I'm not for him. Yeah. I'm going to wait until I have more info. So I'm definitely going to see if I can catch that June 24th hearing, I think it was. Yeah, because I want to follow this one. I want to see where this goes. There's the PSA of the day. Keep your hoo-hoo fresh. Hello, Lisette Panette.
All right, good afternoon, Mr. Vogler. Do you know, is Mr. Wergo joining us today or no?
Well, he is in the courthouse. He was in his office. I didn't know if he was coming in by Zoom.
He zoomed in earlier, and then we had to reschedule it because we hadn't had you notified properly. So now I'm going to place everybody back in the waiting room and give us a minute to contact Mr. Wergo and see if he's coming down, because I don't know if he was told of the new time. So hang on a sec. All right, good afternoon. We are back on the record in 53rd Circuit Court for the County Presqu'île, providing public access in the courtroom and also online. We're here for an arraignment on a outstanding warrant on People of the State of Michigan versus Tammy Lynn Krajewski, file 25-933550FH. Counsel, would you please state your appearances, beginning with the people?
Zachary McLennan on behalf of the people.
Your Honor, Mike Vogler, I'm here representing Tammy Krajewski for this arraignment.
Okay, thank you. And I'm appearing by Zoom from the Sheboygan County Courthouse. Everybody else is present in the Presqu'île courtroom. And Ms. Krajewski, it's alleged that you are in contempt of court for violating your bond in the following respects. It's alleged that you tested positive for alcohol on March 23rd and also March 24th. You have the right to have a hearing on those allegations where they would need to be, your contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of a lawyer at any such hearing. And I know Mr. Gilbert represents you in the underlying case. Mr. Vogler's there to help advise you and assist you with the arraignment today. If you are found to be in contempt, you could be jailed for up to 93 days and or fined up to $7,500. Also, if the court believes that you're not complying with the conditions of your bond, they can revoke or modify that bond at any time. And Ms. Krajewski, do you understand the rights you have and the penalties that you could face?
Your Honor.
Mr. Vogler, do you know how she wishes to proceed today?
Well, right now, Your Honor, I'm looking at a petition that's alleging positive test results on 323 and 324, and then it says see attached. There are no test results attached to that petition. So I've been handed other documents. What we got here?
Okay. The warrant would have just may not have had it. Have you been given a copy from the court file that has those?
I've been given a copy. The court file did not have the test results in them. It had just the bare petition and the court's order.
Well, that's unfortunate. You have them now. It's looks like a BAC readings.
I don't have it for those 2 days, no.
Okay,
Right.
well, I imagine you may want to look at those with her. So let's go off the record. I'll send them over there. All right, can we go back on the record? All right, Mr. Vogler, has somebody provided you with those documents then?
They have, yes.
Okay. And do you know how Ms. Krajewski wishes to plead on the contempt violation today?
She wishes to plead guilty.
Okay, Ms. Krajewski, would you raise your right hand for me, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can put your hand down. Ms. Krajewski, you understand you've got the rights to a hearing as I outlined and the right to the assistance of a lawyer at that hearing?
Your Honor.
Has anybody promised you anything in exchange for your admission to contempt of court?
No,
Has anybody threatened you to make you do so?
no, sir.
Is entering that plea your own free choice?
Yes, Your Honor.
Knowing all that, how do you wish to plead to the allegation that you're in contempt of court, guilty or not guilty?
Guilty, Your Honor.
All right, so Ms. Krajewski, are you on a bond to this court for an OWI third offense? I'm sorry, I couldn't hear you.
Yes, Your Honor.
Okay, and as a condition of that bond, are you required to not use or possess alcohol and to submit to regular testing through a sober link device?
Yes, Your Honor.
Okay, and did you on or about March 23rd and 24th consume alcohol in violation of that bond condition?
Unfortunately, yes, I did.
Okay, Mr. Vogler, are you satisfied with that factual basis?
Yes, Your Honor.
Mr. McLennan?
Yes, Your Honor.
And Mr. Vogler, are you aware of any promises, threats, or inducements for that plea?
I'm not aware of any.
Mr. McLennan?
I am not, Your Honor.
All right, Ms. Krajewski, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and in law to believe that you're in contempt of court for violating the court's orders of bond. I would note that, well, I suppose, Mr. Vogler, any remarks you want to make about what the court should do next?
Well, Your Honor, I believe she's struggling, that's for sure. She is employed at Big Boy. Uh, Brought into jail here, I believe, on Wednesday evening. And she tells me that she has been voted, she's been approved for drug court. And I guess she has another case, and that's from the case out of Oscoda County, Mayo, I guess. And she's supposed to be in drug court on Wednesday at 9:30, so that would be next Wednesday at 9:30 to begin that process.
Okay, thank you, Mr. Vogler. Mr. McLennan, any thoughts about what to do next?
Your Honor, Ms. Krajewski is on felony bond for her third drunk driving offense. Struggled on bond so far with drinking. I think there's a risk to public safety here. I would ask for bond revocation and for the court to find Ms. Krajewski in contempt, Your Honor.
All right, thank you. Well, Ms. Krajewski, when we were in court last time, we had a pending contempt that still is pending for an alcohol usage, but it was only one. And because you told me on that date that you were in the Alpena Sobriety Court program, we thought we'd let you go ahead and do that and continue to monitor with the SoberLink. So it's surprising to me today to hear that you haven't even started that program and you're about to start it. Is there something you want to tell me about that? Don't tell me anything about your underlying case. Is there something you want to tell me about your sobriety court involvement in Alpena?
Yeah, I was under the impression that once they started talking to you and stuff, that meant that you were actually accepted. I didn't know until I met with Nicole a few weeks back that it actually had to be a voting process. Nobody told me that, but I just got the call from Amanda and I did get voted in, and Amanda asked me to be there Wednesday morning at 9:30 to get the process and stuff going, so I could see. I didn't know it had to be a voting process. I thought once you started the counseling and all that, you were just accepted in. I didn't know it was a whole 12 people or whatever got to vote on your process. I'm sorry about that, Your Honor. That was my misunderstanding.
Okay. Well, I've also been handed today several tests showing that Ms. Krajewski has just been drinking an awful lot. And while she's on bond as a beginning to, she's supposed to be beginning a sobriety court program and says she's engaged in some counseling. And then while she's on bond, in this case for a felony repeat drunk driving, and she has to blow into a device several times a day to make sure she's not drinking. And we're getting several positive readings over the last couple weeks. So that shows me that whatever guardrails we've got in place right now, it's not enough to stop Ms. Krajewski from drinking. Obviously, the long-term solution for her is going to be treatment and not locking her up forever. But in the short term, I think public safety demands that I would revoke her bond at this time and remand her to the custody of the Presque Isle Sheriff until further order of the court. We'll set this matter for a docket call and a contempt sentencing. It's already scheduled, I think, for May 5th at 9:30 a.m. So we'll just add the contempt sentencing on that date for what is already scheduled, and we'll address that with Mr. Gilbert at that time. But until we know what the plan is here on this case with Ms. Krajewski, I just can't risk that she gets in a car with how much that she's drinking right now. All right, thank you. So anything further from the people?
No, Your Honor, thank you.
No,
Anything further from the defense?
no.
Okay, I'll see you on March 5th, Ms. Krajewski. Or May 5th, I'm sorry, May 5th.
When you have a SoberLink device that you knowingly have to blow into multiple times a day and you're still drinking, you've got big problems that you need to address.
All right, we'll be in recess.
Okay, there's Mr. Maybe, Mr. Hartel needs to speak with you, so I'm going to put you both into a breakout room for a moment, okay?
Okay, gotcha.
Okay, court calls the people of the state of Michigan versus Robert Darren Maybe, case number 25146 OM. Mr. Maybe, are you able to see and hear the court?
Yes, I am.
So we're here for a couple different things today. My understanding is we're going to plead to a bond violation and the underlying offense. Is that correct, Mr. Hartel?
It is.
All right. Mr. Maybe, I have a bond violation that alleges that on or about April 23rd, 2025, that you did test positive for alcohol. I had placed you on bond on this case on April 21st, 2025. And one of the conditions that I placed upon you was that you were not to consume alcohol and you'll be subject to random testing. Do you understand those bond violations?
Yes, I do. Yes,
Mr. Hartel, how does your client wish to proceed on the bond violation?
On the bond violations, he'd be wishing to plead guilty, Your Honor.
Is that accurate, Mr. Maybe?
Yes. Yes.
Then to the allegation that on or about April 23rd, 2025, you tested positive for alcohol, how do you plead?
Is this for the bond violation?
This is the bond violation.
Okay, guilty.
And did you consume alcohol around April 23rd? So that would have been Wednesday, 2 days ago.
Oh, yes, I did. Yeah.
Okay.
You know,
And
afternoon.
you knowingly did that?
Correct. That's why I want to plead guilty.
And you knew that pursuant to the terms of your bond, you were not to consume alcohol?
Correct.
Do counsel believe the defendants provided a factual basis in which to accept the bond violation plea?
Yes, Your Honor.
Yes, Your Honor.
As does the court. Sir, I find that you are in violation of your bond for consuming alcohol back on April 23rd, 2025. It's also my understanding that we're anticipating a plea on the underlying case.
That is correct, Your Honor.
Mr. Carnes?
Yes, Your Honor, I anticipate that Mr. Maybe will be pleading no contest as charged. The reason for the no contest plea is intoxication, lack of memory due to intoxication at the time of the offense. And the people are simply asking for 15 days jail with no probation. That was communicated to defense during negotiations. Thank you.
Is that a Killebrew or just a recommendation?
It's just a recommendation, Your Honor.
Mr. Hartel?
That is accurate, Your Honor.
You said no probation.
Yes, sir.
Mr. Maybe, have you heard what the attorneys have said in this matter is the resolution to the underlying case?
Yes, I have.
And is that how you wish to proceed?
Yes, no
Will you
contest.
please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Maybe, back on April 18th, 2025, were you on probation or parole?
No,
Were you on bond in any other case?
no,
Other than the plea agreement with the recommendation, has anybody promised you anything in order to get you to plea today?
no,
Has anybody threatened you in any way in order to get you to plea?
no.
And is it your own free choice to plea today?
Yes, Your Honor.
Then to the count or that on or about April 18th, 2025 in the city of Cadillac, Wexford County, you were intoxicated in public, in particular the parking lot of Harborview Apartments. How do you plead? I anticipate you would plead no contest.
Yeah, no contest.
In order to accept that plea, I must have something to review that tells me that gives me enough evidence to find you guilty. I have been provided with what's been previously marked as People's Exhibit number 1. That is a Cadillac City Police Department incident number 2500982. Do the people move for its admission?
Yes, Your Honor.
Mr. Hartel, any objection?
None.
Mr. Maybe, do you understand that by entering a no contest plea, I am able to review this police report to determine whether or not there's a factual basis, and I'm also able to use that for sentencing purposes. Do you understand?
Oh, yes. Okay.
Prior to recalling the case, I had been advised by counsel that this was going to be a no contest plea, so I had taken the advantage to review the report ahead of time. I find that the defendant is guilty of being intoxicated in public. I find that the plea is knowing, voluntary, and accurate. I also find that the interests of justice are served by allowing a no contest plea due to the level of intoxication and lack of memory. In particular, the police report indicates that a PBT was administered and it came back at a 0.191. Additionally, I find that the police were called to the Harborview Apartments due to a disturbance on February 18th. Harborview Apartments are located here in the city of Cadillac. It does appear that this argument was over the old, it's referenced as a show, but I remember it as a movie of Howard the Duck. It's also indicated in the police report, described the defendant as having the smell and odor of consumed intoxicants. He had bloodshot, watery eyes. He appeared to have difficulty understanding the questions. He had to think about the question, then asked whether he needed to think about it. He asked, think about what? So given the level of intoxication and his interaction with law enforcement that day, I find that his lack of memory is a valid reason to enter the no contest plea. Mr. Maybe, I find you guilty of intoxication in public, the 90-day misdemeanor. And again, I previously found you in violation of the bond condition. Mr. Hartel, any allocution?
Yes, Your Honor. I would ask the court to adopt the people's recommendation of 15 days. I do believe that would be appropriate. If I recall correctly, the amount of time he has is about 6 days, so that would put him with good time about halfway through. I understand the way the jail does the good time at all, but I do believe that would be appropriate. He did commit the offense of being intoxicated in public, as the people did note, and as the court did read, it wasn't the most extreme case perhaps, but we do acknowledge that he did violate bond as well. I do believe that he has a lot of work ahead of him to get to the point he needs to be. He has been working with community mental health, which is part of it. It goes deeper than just alcohol addiction, but he is working with them. He has been working for what we can do with our office social worker, Mr. Brian Henniger, but it's a lifelong struggle, and I just wish him the best. Thank you.
Mr. Carnes?
Thank you, Your Honor. I do note that Mr. Maybe caused concern to at least 2 people, and then took up law enforcement time for a bit as well in this. I think 15 days jail is appropriate here. Ultimately, I wish Mr. Maybe would stop drinking, but I don't think he's a good candidate for probation. Thank you.
Mr. Maybe, I realize you took a no contest plea, but is there anything you'd like me to know before sentencing?
I feel terrible because I know Howard personally, and I know he's going through a hard time. So he's a friend of mine, and I'm shocked by this whole circumstance. I'm kind of upset at myself. He probably didn't need that distress to me that day.
When you say you know Howard personally, are you talking about Howard the Duck from the movie you know personally?
That's one of his nicknames amongst his friends. Like he does a lot of tree work, so he knows a lot of the same people I know.
So when you say Howard, you're not talking about Howard the Duck from the movie. You're talking about somebody that you know has a nickname of Howard the Duck.
Correct.
Okay. Thought we had a competency issue there for a minute.
Sorry, I giggled.
Okay. Well, historically, the defendant has a domestic violence from 2006, a malicious destruction of property, 200 to 1,000 in 06, a domestic violence in 15, a littering objects in the pathway of a vehicle from 2017. I specifically remember that case because Mr. Maybe was throwing chunks of concrete onto Mitchell Street at moving vehicles. In 17, there was a malicious destruction of property less than $200. In 19, a retail fraud third. 19, a disorderly drunk. In 23, an attempted larceny less than $200. In 24, a malicious destruction of personal property less than $200. In 24, a disorderly drunk. In 24, another disorderly drunk. In 09, which does not show on his CCH, but does show in our local records, there was a disorderly person. There is no question that alcohol is playing a major factor in Mr. Maybe's life here, and it has for a very long number of years. I do realize in the past he has worked with CMH. I remember one probation violation in particular where he was given the opportunity to work with CMH and that didn't work out, which resulted in a probation violation. Additionally, in this case, he was ordered not to consume alcohol, and 2 days later, we're back drunk in public again. I don't believe that Mr. Maybe is a good candidate for probation. And I realize there was a recommendation for 15 days jail, but given his history, his performance on prior probations, and his performance on bond in this matter, the court will not follow the recommendation. I will order 45 days jail with credit for 6 days. There is a $75 crime victims' rights fee, a $50 state minimum fee, and Mr. Maybe, I will keep the fines and costs at $100 fine, $100 cost, Mr. Hartel attorney fee.
Wait, John.
Mr. Maybe, because I have sentenced you to a term of incarceration, you have the right to appeal that decision. And if you decide that you want to appeal that and need the assistance of a public attorney because you cannot afford one, you have 14 days in which to file the request for the appointment of a public defender. Additionally, any balance that remains unpaid for 56 days will receive a 20% penalty. I also show that you owe this court $2,270.39, and there's been no payments made on those fines. So I would request that once you get out of jail that you contact the court and start making payment arrangements. Mr. Hartel, anything further?
No, thank you.
Mr. Carnes?
No, Your Honor.
Thank you, Jail.
Okay, Detective Hinojosa, which one are you here on? Or both?
I'm here for Mr. Pablo Calderon, and then Detective Chamberlain has the other one.
Okay, all right, this is 251163, the state of Michigan versus Pablo Calderon. Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record?
Detective Mario Hinojosa.
Have you read the type complaint that was filed with the court?
Yes.
Are the facts stated in the complaint true to the best of your knowledge and belief?
Yes.
Can you state the facts that support the issuance of the arrest warrant?
On April 24th, 2025 at approximately 3:17 a.m., Corporal Peak was in the area of Inkster and Ecorse in a fully marked vehicle when he observed a gray 2012 Dodge Journey traveling southbound on Inkster. The vehicle did not have an operable lighting over the license plate to illuminate the license plate at nighttime. Upon observing this, Corporal Peak initiated a traffic stop on the vehicle. Upon approaching the vehicle, Corporal Peak identified the driver as Tyler Sloan via his Michigan driver's license. A lean check of Sloan revealed numerous misdemeanor warrants. Sloan was ordered to exit the vehicle and was detained in the rear of the patrol vehicle while dispatch checked other jurisdictions for the warrant. While dispatch checked the warrants, Corporal Peak asked the front seat passenger for his name and he stated Francisco Calderon, provided the date of birth 2/12/94. A lien check of Calderon revealed no record but a Third Circuit felony warrant for Calderon. Upon observing the driver's license and verifying his identity as Pablo Calderon. Calderon was ordered to exit the vehicle, which he did, and was placed under arrest for his felony warrant. With the consent of Sloan, officers conducted a search of the vehicle and located an Adidas backpack in the trunk, which was open to the entire passenger compartment. In the backpack, Corporal Peak located 3 bags of suspected methamphetamine weighing 4.49 grams with packaging. Also in the backpack, Corporal Peak located a notebook with the name Pablo Calderon written on it. The methamphetamine and backpack were seized as evidence. Sloan was released from the scene with a traffic citation, and Calderon was transported to the station. The narcotics were tested using a true narc system, which came back positive as methamphetamine.
Okay. Did you sign the type complaint before you sent it over to the court?
Yes.
All right, let the record indicate I find probable cause to believe the accused committed the alleged offense, and I'll therefore issue the warrant. I'm keeping a notebook with your name written on it in the backpack with your drugs. It's like allegedly. That's an interesting fact. Yeah.
Yep.
Okay. All right. He's in custody. Anything on bond?
Well, whatever the court recommends, Your Honor.
All right. Thank you, Detective. Right. Do you know, did you say Chamberlain's coming in on this other one?
Yep, he's ready right now.
Oh, perfect. Okay, great.
All right. Have a good weekend.
All right. You too. Thanks. Who are we seeing next?
Next is Mr. Calderon, ma'am.
Okay. Thank you. Hello, sir. Can you hear me okay?
Yeah.
This is 251163, the People versus Pablo Calderon.
Good afternoon, Your Honor. James Guzecki on behalf of Mr. Calderon. Waive reading of the complaint, stand view. Request a court-appointed attorney. There's also order to preserve evidence. I believe there's no hold, no bond.
There it is. Okay, sir, I've signed the request for court-appointed attorney as well as the ex parte order to preserve evidence. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. If you can't afford an attorney, one will be appointed to represent you at public expense. You have 2 dates coming up within the next 21 days. The first is your probable cause conference, and that will occur on May 5th of 2025. And you can appear at that hearing via Zoom. Following that, you will have a preliminary exam, and that will occur on May 12th of 2025 in person at the 23rd District Court. At that hearing, the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. Sir, you have warrants out, including a no bond hold. So, and given the allegations here, I know there's no allegation that you were operating the motor vehicle, but certainly concerning. You have a $30,000 10% bond. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot possess or have access to firearms or other dangerous weapons. You cannot consume alcohol, consume or possess alcohol or illegal drugs. You could be subject to testing on demand, and we will see you on May 5th for your first court date. We're all set. All right, this is 251164, the People versus Walter Bronner Jr. Detective, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state your name for the record?
My name is Detective Jordan Chamberlain.
Have you read the type complaint that was filed with the court?
I have.
Are the facts stated in the complaint true to the best of your knowledge and belief?
They are.
Can you state the facts that support the issuance of the arrest warrant?
Yes, ma'am. On 4/23/25, Taylor Officer Lamar Frederick was at the red light at Inkster and Ecorse when he observed a gray Range Rover traveling eastbound in the westbound lanes. Officer Frederick attempted to stop the vehicle with his license sirens activated when the vehicle continued onto I-94 eastbound at a high rate of speed on the left shoulder. The Range Rover continued eastbound at approximately 100 miles per hour in the fast lane on I-94 while Officer Frederick continued to chase the vehicle. While approaching I-94 in Telegraph, Officer Frederick observed the vehicle cut across multiple lanes of traffic, striking a blue F-150, then a black Dodge Dart, and continuing eastbound I-94. The vehicle then lost control and crashed at I-94 in Monroe in a single vehicle accident. Officer Frederick arrived at the final resting place of the vehicle and began giving the driver of the vehicle, ID'd as arrestee Walter Browner Jr., loud verbal commands to exit the vehicle. Browner complied with Officer Frederick's command and was taken into custody. An inventory search of the gray Range Rover was performed. While searching the vehicle, a silver and black Glock 43X was found inside the vehicle. The firearm was loaded with 7 live rounds. The vehicle was then towed by area to area. Browner was then transported to Taylor Police Department without incident. Once at Taylor Police Department, a search of Browner was performed. Inside Browner's small handheld bag that was brought with him to the jail were 2 unlabeled pill bottles. Inside the pill bottles were a mix of pills. Drugs.com pill identifier identified the blue pills in the bottle as alprazolam, a scheduled 4 controlled substance. The pill identifier also identified the other pills inside the bottle as pentramine, a schedule 4 controlled substance. Browner's MAPS report showed he has not been prescribed either one of these controlled substances. A lean check of Browner also shows him to not be in possession of a valid CPL.
Okay, did you sign the complaint before you sent it over to the court?
Yes.
Let the record indicate I find probable cause to believe the accused committed the alleged offense and I'll therefore issue the warrant. Detective Chamberlain, anything as to bond?
I would leave it up to the court's discretion, ma'am.
All right, thank you, you're all set.
Thank you.
All right, sir, time for court.
Sir, can you tell me your name?
Walter Browner.
All right, this is 251164, the People versus Walter Browner Jr.
Good afternoon, Your Honor. James Guzicki on behalf of Mr. Browner. Waive reading of the complaint, stay on mute. There's an order to preserve evidence. Mr. Browner indicates he'll hire his own attorney. We're asking for a minimum amount of honor. Does not appear that he has a, other than a misdemeanor, criminal history.
Okay, he has out of state criminal history. Went to federal prison, according to this. So, Mr. Browner, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you. You have 2 days within the next 21 days. The first is your probable cause conference. You can appear at that via Zoom. That's set for May 5th of 2025. Following that, you will have a preliminary exam where the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. That exam will occur in person at the 23rd District Court on May 12th of 2025. So, Mr. Browner, you intend on hiring your own attorney?
Yes.
Okay, are you going to have that attorney available by your next court date in 2 weeks, or do you want me to have someone appointed to stand in until you get your attorney?
No, I will have one.
Okay. All right, I did sign the request or ex parte order preserving discovery. Allegations in this case are not good. Vehicles were allegedly struck in this incident of the fleeing and eluding. There's allegations there was a firearm and illegal drugs in the vehicle at the time. Sir, you have a $35,000, 10% bond. The GPS tether. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot possess or have access to firearms or other dangerous weapons. You cannot consume or possess alcohol or illegal drugs. You may be subject to testing on demand.
Thank you, Your Honor.
We'll see you at your next court date, sir.
Wow. I think other than Howard the Duck, and that one was clearly my favorite. I think my next favorite has to be the guy who kept his drug notebook with his name on it in his backpack. They don't catch the smart ones. Oh, man. Thank you guys so much for coming out and hanging out with me again tonight. I had a lot of fun. I was hoping to make it on earlier today and life happened. And yeah. Oh, there's my sweet Mr. Man right there. There's my baby. Look at you. Oh. Yeah, I think I need to take some cold medicine and go night. Yep, we got Earl right there in his box. Right by my Australian animals right there. Yes, he's a brat cat, but he's my baby. So I'm gonna hit up the Dayquil and the pillow. Me too. Kind of partial. A little bias. Oh, Charlie. Well, just don't bring me soup. I'll be like that first lady. I still don't understand what her complaint was, that she was pregnant and he kept trying to bring her soup. I don't understand why she got so mad about it. Happy birthday again, Eileen Carlan. Thank you guys for coming out. Be safe, be well, sleep sweet, and much love.